I've been watching the Brenden Banfield murder trial here on WUSA 9+. We appreciate you staying with us. Not too much has happened in the last few hours. We have heard from the same gentleman, Harry Litsky. He is a private investigator and he has been testifying to some of the forensics evidence in this case. Here with me is Frank Salvato. He is our legal analyst, a criminal defense attorney here in the DMV. Do want to let you know that we are going to be taking your questions. I know some of you have already been putting them in the YouTube chat, but you can also text us. If we could put that number up on the screen, the number is 202-895-5599, and we'll be taking your questions momentarily. Frank, a lot of not too much happening, but you know, we have learned a little bit more about some of the devices that Harry Litsky has been analyzing. Most of this is from Detective Brendan Miller's findings. Now he's the forensics analyst who was with the Fairfax County Police Department at the time. He's still with the department, but he was transferred out of the unit. And his findings, he says, found that Christine never lost control of her devices. Again, important to note that they are talking about devices and can't necessarily say that means the person had the device at the time, right? These are just the devices that they're referring to. Frank, this has been going on all day. We've been hearing from Harry Litsky. We heard from him pretty much all day on Friday. You know, I know when we talked Friday, the conversation was, defense attorney John Carroll is trying to hold things out till the weekend, especially knowing that we were going to have possibly a snow day or two. We ended up getting two. Why is he still going so slowly, do you think?
Well, I think he's definitely more organized. You saw the judge kind of chastise him at the end of the day Friday and say, you need to be a little bit more organized. He is definitely more organized. The testimony is a little bit tedious, understandably. However, you have to understand the dichotomy here. Really, the forensic analysis provided by the Commonwealth thus far has largely been Juliana, who has talked about that they stealthily got control of Christine's work laptop and were able to do this in a very secretive manner. The key issue in the case, really, at this point, is who placed that ad. So this testimony, although tedious, if you really step back and look at it, I know it's tedious, I know it can be boring, and everybody wants to see whether Mr. Banfield is going to testify or not. But if you do a comparison between the Commonwealth's expert witness so far, which I would say is Juliana, compared to the defense's, it seems like the defense is scoring some, albeit boring, they're scoring some points on who had control of this laptop and therefore who placed the FedLife ad.
Yeah, and Frank, you know, you mentioned who had the control, right? And there was a portion where Mr. Litsky said that his findings showed that Juliana's phone was in a park, so not at the home at the same time as when the Gmail account being used to make the FetLife account was created. And the prosecution made a point to say, you're talking about her device though, that doesn't mean Juliana was in that park. She could have been at home, the device could have been there, etc. Do you think that we're going to see Juliana get brought back up to the stand to kind of answer some of those questions?
I would be surprised if she takes the stand again. I think they scored a lot of points against her, and I think putting her up there again would probably be more detrimental for the prosecution. I would expect her not to testify again. But that is an interesting detail, right, as we move on. And don't forget, in closing statements, it will not be tedious, it will not be boring, and it'll be up to Mr. Carroll to synthesize all of this evidence into a coherent, strong message that perhaps raises that reasonable doubt about who actually placed the ad.
All right, I'm going to ask you this question now, and then I'm going to ask you again at the end of this conversation. Again, if you do have questions for Frank, text us at 202-895-5599. Frank, do you think Brenden Banfield is going to get up there on the stand?
I do not think that he will get up there on the stand. As I indicated last week, I think they've done enough now. But ultimately, it is his decision whether to testify. That is something, when it comes to evidentiary issues, objections, what questions to ask, all of those rudimentary things in trial, that's up to the lawyer. The lawyer gets to make those decisions. One of those sacrosanct decisions that a client can make and can overrule you on is whether they want to take the stand, whether they want a jury or a non-jury trial, whether they want to plead guilty or not guilty. Those are really the holy trio. He may have overruled Mr. Carroll and indicated, listen, if I'm going to go down, I'm going to go down telling my side of the story. Personally, and the way the trial has played itself out, I would not think that he would take the stand or that he necessarily needs to take the stand, because right now, as we've discussed, all the attention is on Juliana and her testimony. Once he testifies, all the attention is on him, and he has a fair amount of things that he would have to explain. I anticipate that he would not, but without knowing what Mr. Banfield is thinking, he's certainly writing a lot of notes. Maybe one of those notes is, I can't wait to get on the stand.
Yeah. Well, I will mention, I was able to watch back the video of the moments that conversation unfolded. As we know, that conversation between John Carroll and Judge Penny Ascarati, it happened prior to the jurors being in the room, and it happened prior to Friday morning's hearing. And, the judge said, does Brenden Banfield intend to testify? And John Carroll said yes. And you could see this look of surprise on the judge's face, but also Brendan's face. He kind of jerked his head, and he looked a little surprised. So, we had spoken on Friday about this potentially being a tactic to keep the prosecution from being able to really focus on their closing argument statements and instead have to focus on coming up with some cross-examination questions. Do you think that was the strategy, or do you think Brenden is really honing in to testify?
Well, lawyers can be very crafty, oftentimes too smart by half. Right? In order to win a jury trial or to have a good relationship with the judge, you need to answer those questions directly. So if a judge asks you, does your client intend to testify, or will your client testify, or something like that, you do have to answer that question. He has to keep his candor with the court. That's required. But it's all in the words that he used, not unlike what the prosecutor would say. Do you intend to call any more witnesses? Yes, we intend to call 3 more witnesses, but they may not be calling 3 more witnesses. Same thing with Mr. Banfield's testimony. Mr. Carroll could say, yes, he intends to testify, but without a doubt, he could reverse course and say, you know what, we've thought about it over the weekend, and now he does not want to testify. I think it's more of a tactic to keep the prosecutor working over the weekend on various things. Do I get ready for my closing? Do I get ready for cross-examining Mr. Banfield? Right. It could be straight up that he intends to testify and he is going to testify. Again, I would lean against that. But when the court asks you a question, you do have to answer honestly, but I think he couched the language a little bit so he could go either way on it.
All right. So Frank, last week we heard the audio and we saw Brenden Banfield on the courtroom as he was watching the body camera footage and listening to the body camera footage of the moments he found out his wife had passed away, that she died from her injuries. I do believe we are able to play you some of that video. We mentioned earlier that we had some clips for you. So if we can, I'd like to play you some of the body camera footage that we just got in of those moments when Brenden was finding out his wife had died. Yeah, so actually we're looking for the body camera footage. So we were working on getting some body camera footage of that actually happened. So that was Brenden obviously reacting himself to hearing the audio, but there's new body camera footage that shows Brenden. It should show him in the hospital as this is all unfolding. Do we have that video? Are we able to show that with our viewers?
Check what?
The status of his wife, ma'am.
Hi, sir. My name is Gina. I'm one of the doctors here. Your wife has died. So sorry.
Where's the daughter?
Where's what?
She's still at the scene, sir. She's with the other officers.
Would you guys be able to ask someone else to bring some tissues? That's the nurse.
heads up. Body cams are still on.
Okay.
It's okay.
Just yell at me, I'll get out of your way.
What's that one?
They said he wants to be evaluated, so I'm going to.
Okay, no problem.
All right, so that was just some of the body camera footage. I believe the whole thing is about 50 minutes long, and it is hard to watch, but you know, it shows us a different side of Brenden, if you will. It shows us the moments he found out, and you know, we'll try to get our body language expert to weigh in as well. And I can tell you that we do have that footage, the full footage for you up on our website, WUSA9.com. We're also going to link it in the comments on YouTube, so if you do want to watch it, you do have the ability on there. I do want to bring in Matthew Torres. He's been in the courtroom for us all morning long. He's been in the courtroom every day since the trial started. Matthew, you know, we're hearing a lot of comments on YouTube from some of our viewers talking about the jurors and wondering if the jurors, how they're looking, if they're bored. What's kind of been the reaction you've seen on their faces as they're listening to this testimony today?
Yeah, Katie, I will say it does seem like it's dragging. I did see some of those comments on YouTube as far as this seemingly long, questioning with this expert. The jurors, surprisingly, seem engaged. They don't seem fatigued by the length of questioning that's been taking place. They seem focused, as I've said before, taking notes. So I think it's the people, the gallery, the ones, for instance, us, I know some people have kind of stepped out just to take a little bit of a breather because it does seem to be repetitive in some cases. You could also tell how frustrated Jenna Sands seems to be as well when it comes to the next exhibit, saying no objection, just to kind of help move this along. But as far as the jury members, they seem more engaged than what you'd expect.
What you said, it's a little hard to hear you, Matthew, but I think you said that they look more engaged than they did last week. You know, Frank and I were talking about that, how some people are saying this seems kind of boring, but you're not getting that sort of thought when you're looking at the jurors. Are they taking notes and things like that?
Yeah, they're taking notes. Hopefully you can hear my audio better. They're taking notes, they're paying attention. And when we were talking amongst ourselves with the people who are in the gallery just as we went on break here, we were all agreeing that they didn't seem so bored. They didn't seem to be losing attention or being distracted, at least the first 2 hours of trial so far. It depends on, I think, how long we'll have this this witness on the stand, because we still do have that, if you might remember from last week, that audio expert that's still waiting to testify and come back. So I think maybe the few days break really helped the jury, but as far as whether or not they're paying attention, yeah, they don't seem fatigued.
We saw that the judge and both attorneys were brought up to the bench, and they were up there for about 15 minutes. And I think a lot of us were wondering what that conversation was. Were you able to hear any of it? Did the judge kind of give any insight on, you know, a couple of different things? One being, is there going to be court on Friday to make up for this week? But also, did she mention anything about Brenden getting up on the stand?
No, nothing at all, because usually, obviously, when they go to the bench, that's when they kind of blur out that audio so you wouldn't be able to hear. They were there for quite some time, so to me, I was wondering if she was making sure that the exhibits, especially after last week, after John Carroll was admonished to make sure that things are according to plan, that things are more organized this time around. But no, we didn't have any indication whatsoever. I did see Jenna Sands speaking with one of the detectives just out in the hallway soon during the first break, and so curious to know what that was about, but no indication at all.
And you have a lot to get back into the courtroom for, but thank you for joining us. You know, Matthew's talking about how the jurors look interested, and you know, you mentioned that too, and I see in the comments some people saying it's not boring, it's just technical, and I think it is important. Some people find it boring, others find it fascinating. At the end of the day, it's important, that's for sure.
That is true. There's 12 jurors on there.
Right.
Some of them might be, if you're looking at a prize fight, some might be looking for that big knockout blow, that overhand right that's going to knock the Commonwealth's case out of the ring. You saw some of that with the cross-examination of Ms. Magalhaes. This is a jab, 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 jab type of fight, which maybe over the first few rounds might be a little bit less interesting, but I think the big blows are coming later. What is really fascinating to me is how will the prosecution deal with this witness? This witness is not enthralling. He's not magnificent on the stand. He doesn't have a huge personality, but certainly he is very well credentialed. He used to work in law enforcement for, I think, 20 years or so. How will the prosecutor deal with him? Will they get into the technicalities? Will they get into the weeds, so to speak? I don't think so, because they're going to get knocked around by somebody that knows their field. I think they're going to get in and out with some cross-examination and just try to be done with it. That will be the most interesting part of this next little bit of time, is how the prosecutor deals with this expert witness.
Yeah, and we've heard Jenna Sands, you know, her objections were more so to keep him focused, because he keeps saying things like, well, you know, Christine, it shows Christine was home at this time, and the prosecution says, no, it shows her device was home at that time. Is that what we're going to continue to see, just those little? We're
going to see some of that. That is effective, because I've done that on the other side. That is effective to a point. However, how many times in a person's life are you really separated from your device? That can work out. You know, the forensics track the device, not the person. But after a period of time, if that evidence keeps building, you can only say that one or two times. Usually your device is with the person. So we'll see what tactics she takes, but if I'm her, if I'm the prosecution or advising the prosecution in any way, shape, or form, they've got to be really careful with an expert witness, because as we've talked about before, sometimes lawyers think, or oftentimes they think they're the smartest ones in the room. But when you're dealing with an expert witness, they're usually the smartest ones in the room on this particular subject. I would expect her to be short and punchy on her cross-examination, make that exact point, give a few examples, and sit down. We'll see if she really wants to engage him or not.
You know, we talked about the beginning of today's hearing, and let's talk about Friday too. You know, it ended with the judge giving very stern and to the point instructions. She wanted everyone, specifically John Carroll, I think that was directed at him, to come in prepared today. Some of the people in the comments asking if you feel that he is prepared. Does he seem more prepared today? Is this just his personality? What's happening here?
I think he's had a few days to kind of get things together and organized. There is a lot going on at the defense table. There's a lot going on the prosecution table. But having sat at the defense table for 30 years or so, there's a lot going on there. The prosecutor really only is dealing with the person next to them, which is typically the other prosecutor or the police officer who's been through a trial before or whatnot. Mr. Carroll's dealing with a lot more. He's dealing with actually an individual who's writing him notes, who might be a little bit more fidgety or demanding than other clients. So he's dealing with that whole dynamic. He's also dealing with an expert witness who's come in and maybe he had to set up his hotel accommodations. You know, he's dealing with all of that. Then he's trying to stay organized through 300, 400 exhibits. And he's got a judge whose patience is wearing thin. As it gets to the end of the week, like all of us, we get a little tired, we get a little annoyed, more easily annoyed. But she didn't chastise him really in front of the jury at all. She just chastised him out of presence of the jury, which was a very professional move. He does seem more organized. He seems a little bit more sprightly. He's had the weekend to relax a little bit, and he's come out with a little bit more fire. But again, a technical witness, it's hard to have that huge amount of flamboyance.
And, I think it's important to mention, she said it's about respect when she was saying it. She was saying, I want you to respect me, but I want you to respect the jurors' time and all those things. We heard Matthew mention this other witness. So briefly, another gentleman named Nick Barrera, he was called to the stand, and they were having some technical issues, which I think just added on to the frustration by everyone in the room. So I think we will probably hear from him again. Curious to see what he's going to say. We do have some more body camera footage that we're going to play for you. And Frank, I do want to just talk to you a little bit about the importance of why this body camera footage was shared in the courtroom. This is footage of Brenden Banfield in the ambulance being taken to the hospital.
So you're not hurt
and a
anywhere,
reminder,
is that
they were
not
taken
your blood,
separately
correct?
to the hospital. So he is not with Christine in this moment. So what you're watching is that conversation happening between the officers and also, the EMTs. They're checking him out. And we also have some more video of them actually in the hospital. So maybe we can show that as well. But Frank, these videos, what is the importance of showing those videos? What is the relevance of showing them in the courtroom to the jurors?
Well, it's in the eye of the beholder. Some would say, well, he's putting on some type of show or whatnot. But I think the importance of it is that the jury can see in that moment how he reacted. And I think when that doctor came in and quite bluntly told him the news that his wife had died, it really demonstrates a couple of things. First of all, the humanity of this case. As we've talked about before, this is the humanity of this case goes without saying. And you have two decedents, a child. He's on trial for his life. But putting that aside for the actual strategy in the case, it shows that he did react in an emotional way. It appears to me that is emotion that Mr. Carroll is trying to get in front of the jury. They need 12 to convict. And if 2 or 3 of those juror members look at that and say, you know what, I believe that is true, raw emotion, that in and of itself can create a reasonable doubt in a particular juror's mind. So Mr. Carroll's doing a nice job in dealing with not only the technical things, perhaps there's an engineer or two on the jury, but he's also dealing with the emotional aspect of it. So he's trying to cover a lot of subject matter, technical and emotional. That really is just trying to appeal to the emotions of the jury. There's no real relevance to that body cam, in my opinion, but it's relevant enough to get in front of the jury and perhaps show that he was in reality very emotional, and that is not something that a killer would demonstrate learning the news of his wife's death. Two sides to every story. Someone could look at that and say that that was faked emotion. Everybody reacts to grief in a different way. People can shut down, people can get very big, they can get very small. Ultimately, I don't know if the jury's going to put a lot of weight onto that type of testimony, but he's just trying to get a little bit of an emotional connection to the jury.
All right. Well, you can watch that entire body camera clip on our website, WUSA9.com. We will also put it in the comments for you on YouTube, so you can check all of that out. Let's get to some questions that we've been getting from viewers, both on YouTube and also people texting us. And the number to text if you would like to submit a question for Frank to answer is 202-895-5599. Again, that number is up on your screen. It's 202-895-5599. And, court resumes at 2:05. That's when the judge said they were going to come back. So let's see if we can get through. We have a lot of questions for you, Frank, but we're going to try to get through as many as we can for you. Let's start with this one. I saw this a little bit earlier, and it was also of interest to me. This trial was slated for 4 weeks, right? Initially, the judge said we were moving quickly. Things were going very quickly. She thought we were going to be done with the trial within a matter of days. Fast forward to today, we lost 2 days. Now we're entering week 3, but it's also middle of the week. What happens if they need more than the 4 weeks that were allotted?
That is really unlikely.
Okay.
But if they need more time, the jurors will find more time. In my experience, jurors in this jurisdiction, all jurisdictions, but in Northern Virginia in particular, are very conscientious. They call it jury duty, right? It's not jury fun. It's not jury, I'm off of work for a few weeks. It's jury duty. There was a federal judge who would often tell the jurors that in the beginning of the voir dire. He would say, ladies and gentlemen, they call it jury duty or jury service. It may stretch a little bit longer. They've probably taken into account another couple of days or so in jurors' vacation plans and that type of thing. It may go a little bit longer. I think this is going to rapidly accelerate once we're done with this witness. I think we're going to rapidly accelerate to the end. It wouldn't shock me if they're doing closing statements on Friday of this week in a couple days.
Okay, and so I know we have at least one more witness. Possibly if Brenden takes the stand, that could go on, I imagine, quite a bit. So you think they'll be done with witnesses by Thursday, Friday?
I think they'll be done by Friday, would be my guess.
Right.
We'll see if Mr. Banfield takes the stand. And we can't forget, because the burden is so high, the Commonwealth gets to rebut any evidence that the defense has presented.
Right.
So the Commonwealth has gone first. The defense has worked their way through some witnesses. Maybe Mr. Banfield testifies, maybe he doesn't. But now the prosecutor will get a chance to do a rebuttal. What'll be interesting about the rebuttal is, does the prosecutor think, you know what, I've done enough, I want to get it to the jury. You see some of the objections are more with a sigh or let's get this over with.
Right.
We'll see if they do anything on rebuttal after the defense case or not. I would expect if they do, it would be a short witness or two, but they have the chance to put on a forensic expert if they want. Will they call Juliana to the stand? Unlikely.
Yeah.
Will they call another expert to the stand? Unlikely. I think they'll probably call a couple of witnesses just to get something out in rebuttal, but I don't think they're going to do anything expansive. So putting that all together, I would say by Friday the testimony should be done. Banfield is the wild card.
Right.
If he testifies, how long will that take? That could take a good half a day or a full day.
Yeah, and I believe Jenna Sands said on Friday that she had one or two witnesses, so that would make sense. This might be a silly question, but is there a scenario where the prosecution would call Brenden Banfield to the stand? Is that a thing?
They're not able to do that. He has his right not to testify. The jury will be instructed. There is no inference for him not testifying. But once he gets up on that stand, it's all open. There's a lot of subject areas that if I'm John Carroll, maybe I don't want to be explored.
Right.
I've never met Mr. Banfield. Maybe he will do great on the stand. That, like we've talked about, high risk, high reward.
Let me ask you this. I know you've handled a lot of cases. If you're the prosecutor in this case and Brenden Banfield gets up there on the stand, what is the first question, the most important question you're asking him?
I think the first line of questioning may be something. You always want to start off your cross-examination with something is going to be successful, right? Primacy, recency. You want to start off with something powerful and that's going to be successful. You don't want a slow build up. That's boring. And the jury is expecting you to really eviscerate him on the stand. He's the guilty guy. He's involved with 2 murders. They expect the Commonwealth to really go out and get him on the stand. So I would start off with something that I know I'm going to be successful on, that I know is going to hit home, and that I know he cannot escape from. So the topics could include the relationship that he had with Juliana. That is something he's not going to be able to run from, that he will have to admit to. That's probably the area I would start off with. It shows his bias, his motivation, and I know what answers I'm going to get. Or you start off with something about the blood spatter evidence or something like that. But I think those are topics that he's well versed in, that he might be able to move around on a little bit. So if I'm cross-examining somebody, whether it's a key cooperator or somebody along those lines, I want to start off with something that I know I'm going to be successful with. I don't want to start off with a Hail Mary pass. I want to run for a first down and I know this play is going to work. So that's what I would start off with if I'm the prosecutor.
Okay. I'm interested to see how this all plays out. Let's get to our next question. Somebody asked, does Brenden need to be convicted for Juliana to get her deal, or does she only have to testify against him? Frank, we have her plea agreement here today. First, let's answer this question, but then the question everyone just continues to ask.
Yes, her agreement is not predicated on the success of her testimony. Most cooperators agreements have language along those lines. This one does not. But let's say she agreed to testify, and for some reason Mr. Banfield had a heart attack or passed away or something happened before the trial. That doesn't impact that she fulfilled her part of the agreement. So no, the success or lack of success of the prosecutor's case has no impact on her plea deal whatsoever.
If there is a mistrial or a hung jury situation, I know you answered this last week as well, but is there a scenario where she could potentially have to testify again, or is it just a one-time thing?
She would absolutely be required to testify again. Her time in jail, and we'll get into the details of it, her time in jail is capped at time served by the prosecutor's recommendation. Now, if there's a mistrial or a hung jury, they have to do it all again. That might be 6 or 9 months down the road. Everything is in limbo. She stays where she is. She stays in jail. They have a redo, and they do the entire thing over again. Now, if that happens, and she has to sit tight for another 6 or 9 months, sometimes when you have a cooperator who's sitting there in jail for 6 or 9 months, who has expected to get out right away, and now they have to sit there, they often do squirrely things when in the jail. She may reach out to more journalists. She may do some more phone calls with people that are not helpful for her testimony. So that delay, if there is a hung jury, only inures, in my view, to the defense's benefit. Prosecutor always does better in a second trial, but with a witness like this who might sit in the jail for a little bit longer, she might get a little bit fidgety as well and start to do things that are not helpful.
Happening. Yeah, we've already seen that happening. You know, everyone keeps asking, she is set to get time served, meaning she would be free after this, but free in some capacity. She would be deported back to Brazil. We do have her plea agreement here, and we can put that up on our website as well. And Frank, you know, everyone keeps asking, is there a world in which the judge says, I'm actually not going to agree with the agreement that you were given, the deal you were given, and I'm going to sentence you to a longer term? Is that possible for that to happen based on what you're reading here?
It is possible. Looking at the paragraphs of the plea agreement, which again, I commend both sides to this agreement. As we talked about, I think the prosecutor had to make a deal in this case. They had to reach terms with her because they needed her testimony. There probably would not be a trial against him, or a successful one, without her testimony. So they had to make a deal. No matter how favorable the terms seemed to be, they had to make a deal. And certainly her attorneys have done a nice job in negotiating the best terms. But according to the terms of the agreement, the Commonwealth will recommend a certain sentence, that it be capped at time served, provided that she continue to cooperate. But that is a recommendation. That is not binding. And certainly the court, by the terms of this agreement, may accept or reject the agreement. So the court is not bound by this agreement. It is very rare for a judge under an agreement like this to go against the terms. Very rare, because if you think about it, then there would be no motivation for both sides to make an agreement, whether it's in a civil case, a criminal case, a murder case, a drunk driving case, a drug case. If the parties didn't have faith that the judge was going to follow the agreement, then there would be less agreements. If every time you reach an agreement with the prosecutor, you go up in front of the judge and the judge says, you know what, I'm not going to do that, then you would never reach an agreement with the prosecutor. The system would get bogged down. We would do trial after trial after trial, and there would be no deals whatsoever. I would expect the judge to follow the terms of the recommendation, but it is only a recommendation.
Well, let me ask you this. Is it Judge Ascarati who would be handling this plea agreement and making the decision as well, or would it be a different judge? Is that clear to you?
It looks like
does it say on here?
It looks like it's Judge Ascarati's case and her signature.
Okay.
Although I couldn't say that for sure. So, but I would expect, yes, it would be her that
Is
would
it
handle
usually
the case.
the same judge?
Usually.
Okay, interesting. All right, thank you for some context there. And I know we keep asking that question, but a lot of people want to know what happens with Juliana. A couple of different questions, worded a little differently by different people, but the word ineffective counsel keeps coming up in the comments. People keep asking if what is happening on our screens is considered ineffective counsel. Is that ineffective counsel to you?
No, there's zero chance of that. Ineffective counsel has to be representation that falls so far beyond the norms of criminal defense, and it has to prejudice the client. There have been cases where lawyers have fallen asleep at the defense table and have not been found ineffective assistance of counsel because there was no prejudice. I know it's not moving in the same way as you might see, but the jurors are engaged. Matthew indicated the jurors are engaged. They're taking notes. They're not saying, oh, wow, this is terrible. He's doing a really nice job. Sometimes you have certain ingredients that you have to deal with.
Right.
And this is one of the ingredients that he has to deal with. He has to just work his way through this testimony. It's not easy. It's not wonderful. It's not amazing, but in no way it's ineffective. I think he's really done a nice job. This is a difficult case for the defense.
Right.
And he's done a nice job. If half your viewers are talking about Juliana, that's all he needs.
Yeah, and let's elaborate on that a little bit, because people are not thrilled. Some people are not thrilled when you're saying that the defense has done a nice job. You're not speaking to that per se, what we just saw. You're speaking to the overall poking holes, right? Can you clarify what you mean by he's doing a nice job?
Sure. He's doing a nice job because he's dealt a very difficult case, right? Would he get up there and blow away the government's case and Juliana say, yes, I made it all up, I'm lying? Like, that's a pretty high bar.
Right.
He's also dealing with a terabytes worth of evidence. And the facts are difficult. It's a double murder case. The gentleman had a relationship with his babysitter. There's some really bad facts in there. So I want to say he's doing a nice job. Sometimes you're doing a nice job with what you've been given. If you've been given hamburger, you're not making filet mignon, right? If you're giving filet mignon, then you better make filet mignon. He's been given a very difficult set of facts. He's working his way through those. We'll see what the end result is, but in terms of doing a nice job, it might not be exciting, it might not be wonderful, it might not be the way other lawyers would do it. I think his opening was probably shorter than what I would do, but at the same time, the only thing that matters is those 12 people in the box. It doesn't matter what anybody else is doing. If the judge yells at him, it doesn't matter. If his client writes too many notes, it doesn't matter. It only matters what those 12 people are thinking about the job he's doing. That's the only thing that matters to him.
And we talked on Friday about how he's walking this line of annoying the jurors. Maybe not so much today. It sounded like they're back on page. I'm sure they were all looking forward to the weekend, not thrilled to be there on a Friday, as court is only supposed to go until Thursday. But do you think, talk to me again about Friday when we were talking about how he was walking the line of being annoying to the jurors, and you mentioned to me that that's okay. You just apologize at the end. Can you talk about that a little?
Sure. I mean, I think in your closing, my philosophy always is when I leave the house, everybody that I encounter, and I try to go through life this way, everybody I encounter is a potential juror who's looking at my behavior. Am I a jerk in the cafeteria line? Am I gracious to jurors that are going through the same security as I am? Those types of things really matter. He's only concerned with what those 12 people are going to think at the end of this.
Right.
So at the end, usually I will say to the jurors in closing, if I have done anything to offend you, if I didn't talk enough, if I talked too much, if the expert witness that I chose was just too boring, if I asked too many questions, or I kept you here on a Friday, or I wasn't organized on my exhibits, I own that.
Yeah.
But don't take that ownership and use it against my client, who's an innocent man. Use it against me, and really disregard that, because it's really about him versus me. So you can apologize to the jurors as long as you're heartfelt and honest. We don't know if the prosecutor has annoyed the jurors in any way. Have they been difficult in the cafeteria even, or seeing them somewhere? You just don't know what's going on kind of behind the scenes. So I think he will say something in his closing about, hey, thank you for your patience. It's jury service. If I did anything to offend you, that's on me.
Yeah, and also keep in mind the snow, I'm sure, wasn't a delight for them this morning either. When we talk about how they may have to extend or may not have to extend, would we know if alternate jurors have been subbed in? Is there an announcement made? Somebody asked if any of the alternates have been called. Is that something we would know?
The alternates usually sit there in the trial. The jurors usually figure out who the alternates are. They're usually the last ones selected. Some judges, and I'm not sure how she did it here, certainly in federal court sometimes it is kind of a mystery who the alternates are.
Okay.
Because you don't want 3 or 4 alternates. Let's say they have 16 people watching this in the jury box. You don't want 4 people sitting there and saying, well, I'm just an alternate. I'm never going to get involved in the case. So the way that works is if they start deliberation, they will excuse the alternates, the 4.
Okay.
They'll have 12 back in the jury room. If one of the juror members becomes sick, has a family emergency or something like that, that juror can be removed and replaced with an alternate.
Okay.
Okay. The alternate cannot be part of the deliberations, but the alternate is going to be instructed at the end. Don't do any independent research. You're still a potential juror in this case. And I've had cases where an alternate does have to be called in. In that case, they start the deliberations all over again from the get-go.
Wow.
So it can happen. I've seen it happen before. If they run out of alternates and you're down to an 11-person jury, the defense can say, you know what, I'm going to take my mistrial now because I'm entitled to 12, or everybody can agree that the case can go forward with 11. So alternates are set to the side, the 12 start to deliberate. Sometimes there's some substitution if there's like a real emergency.
But right now in that courtroom, those jurors may not know who among them is the alternate.
They may not. They may not. Usually they figure it out because it's at the end, but they want the alternates generally to pay attention, just like everyone else. If you know you're never going to get into the game, then you probably don't know exactly what the score is. So you're just kind of chilling out.
Interesting.
But they'll usually keep everybody's attention by keeping some subterfuge about who the alternate is.
Interesting. We learn something new every day, Frank. Let me ask you this. Does the prosecution and the defense, do they know who the alternates are?
They do.
Okay.
Yes.
So yeah, that was my next. Yeah.
So, and that's part of the strategy, right? Because you may have an alternate who's hates you, who's sighing, who cannot stand this testimony from this expert witness. But what you're thinking as the defense attorney or the prosecutor is, well, I don't really care because they're the 4th alternate. Is really unlikely they're ever going to get to opine and reach a decision in my case. So maybe it's less important that they're over there sighing. My focus is on the 12 people that I know that are going to start deliberations. So maybe there's some engineers or some more technical people. Maybe the 1 or 2 people that are hating me right now because I'm being too boring or not doing a good enough job in their view. It doesn't really matter to me because they're never going to get into the jury room to actually make the decision. Yeah,
and just so everyone knows, Frank is not saying it's boring. He's saying some people may find it boring. I know there's a lot of opinions on both sides. Some people are like, this is great, I'm loving this, and other people are like, snooze fest. So anyway, let's get to another question here. Speaking of that, somebody asked, what is the defense trying to make here? What is the point they're trying to make? And I think they're referring to all of the forensic and technical details.
Yeah, I think they're trying to say that the forensic signature connected to her laptop and her phone is all her. You saw that there were some searches about family vacation, and then Christine actually texted the results of that research to her husband, and then they put it, or she put it on the calendar, somebody put it on the calendar. They're trying to show that she had control over her devices. The prosecution, like we talked about, is going to say, well, that doesn't mean that the 2 of them, Juliana and Mr. Banfield, could not have snuck away with these devices and done a lot of nefarious things on them. But I think what the defense is trying to say is there's so much evidence of her control of those devices, it stretches credibility to believe that Juliana and Mr. Banfield were able to nefariously take away those devices for this long period of time to create a profile, to create a Gmail, and to place these ads. So I think the testimony here has been effective. It's been jab after jab after jab, and the jurors do not seem bored. They seem engaged, taking notes. I mean, your best witness to all that is the reporter in the courtroom.
Matthew. Somebody asked, Brenden seems to look nervous, and they want to know, what do you think? Do you think he looks nervous? I know you think he looks fidgety. We've talked about that.
He does look nervous. That's probably a good thing for him. I don't think anybody charged with this, if I'm on the jury or if I'm advising Mr. Banfield, I would want him to look nervous and concerned. An innocent person could certainly look nervous and concerned. You wouldn't want him kicking back, putting his feet up and being nonchalant. Then he would look aloof, disengaged. So I think he does look nervous, but anybody charged in this type of case, guilty or not, is going to be terrified.
Also, who knows if he is just intimidated by the room? Maybe he's not a people person. We don't know a lot about him. Somebody else asked, again, talking about Juliana, I think that's important too. The defense seems to be trying to poke holes in Juliana's story. They're very focused on Juliana, and a lot of our viewers are very focused on Juliana. Talk to me again about why that is so relevant, that focus on her.
Well, the forensics only come to life for the prosecution if they believe Juliana. Because clearly from this testimony, it looks like Miss Banfield had primary or almost sole control of her devices. The only one that really contradicts that in a way is Juliana. Again, the focus on Juliana is really golden for the defense, which I think plays into whether or not Mr. Banfield will testify. This testimony, this forensic testimony, can be viewed in two ways. One of which is what the defense is doing. The second of which is that, well, Juliana was crafty enough to be able to steal these devices and place these ads and have these types of conversations with people on FetLife. Again, it puts the focus on Juliana, and I think that's only beneficial for the defense.
All right, we'll have to keep watching. Somebody asked, why didn't prosecutors focus on asking the au pair what they were doing during that first 911 call until they called back? Why didn't the prosecution ask her what was going on in those 15 minutes?
That's an interesting question, and I think a very insightful question. Juliana may not have given an answer that they thought was helpful to them, and the defense may have stayed away from that and said, you know what, she may have told in her proffer and her interviews something that was kind of a 50-50. Maybe they weren't doing anything, which didn't really make sense, or maybe they discussed something. Who knows? So I think the prosecutor probably just stayed away from that, and I think the defense, there was probably something in there that wasn't beneficial to them. They probably stayed away from that time period as well. But yes, that was something that I noticed, that some questions, some time periods were kind of omitted from the prosecutor's case, a little bit fuzzy and foggy. That could be that neither side wanted to touch it. Now, it could be simple forgetfulness. Sometimes you get up there and you forget to ask a question or two, and the defense says, well, they didn't touch it, I'm not going to touch it because it actually hurts me. So there's probably something in that, in her previous statement, that might have been a little bit fuzzy, and I think both sides probably just stayed away from it.
Now, if I recall, though, she did, when she was testifying, she did talk a little bit about what was happening, because she mentioned, remember the hand gesture, because it was right after the medical examiner testified and made that hand gesture with the knife, and then we saw Juliana testifying about how when she made the first call, Christine yelled to her, Christine told her to make the call, and then Brenden went like that, hang up the call, and she mentioned how he asked her to get towels and blankets from the closet. And now that I think back, I also remember one of the blood splatter experts talking about how the blankets on the floor that they had photographed, they didn't test those to see whose blood was on there, but then they also didn't believe that those blankets were used to help Christine. So you have to wonder, if you're the prosecution, are you saying that Brenden used the towels, the blankets to hold the knife? Because there was no conclusive evidence of fingerprints, of whose fingerprints were on that knife other than Joseph Ryan's. So I think it kind of leaves a lot of questions.
It leaves some questions, and what seemed to be missing, and I may not recollect the evidence.
There's been a lot.
with specificity, but what seemed to be missing was, okay, the cops are now on their way. This is what you need to tell them. You need to tell them X, Y, Z. You need to be emotional. You need to cry. You need to be big, or whatever, instructions may or may not have been given. I don't remember any of that testimony. I don't think anything along, and I think that's what the viewer was asking
Yeah.
about, is what was the plan, so to speak, as between the time of the deaths and the time that the police officers showed up. I don't remember anything specifically along those lines. It could be that nothing was discussed and perhaps they had discussed it before, or it could have been, on the defense's view, just the reality of the situation, and that Mr. Ryan was involved, and it went down as Mr. Banfield has told the jury, or Mr. Carroll has told the jury, and maybe all of that emotion that you saw in that 911 when the police arrives and
Right.
on that body cam was actually real emotion. Those are the two conflicting sides of the story.
All right, we are getting some texts in as well. If you do have a question for Frank, the number to text is 202-895-5599. And we've got about 10 minutes or so left before court is expected to resume. Right now, the court is on a lunch break. We are expecting them to go until about 5 o'clock today, maybe a little earlier, but I'm curious to see if when the judge comes back, if she's going to talk about having court on Friday. As we know, last Friday they did have court in preparation, anticipation of the snowstorm. So I'm curious to see if she's going to extend that out another Friday and if the jurors will be on board with that, obviously, is a big question. But somebody asked, and I don't know that you'll be able to answer this, but they said, was there ever a life insurance payout on Christine Banfield? And could that have been a motive? Why hasn't the subject of life insurance ever been brought up by the prosecution? I haven't heard anything about that.
I haven't heard anything about life insurance. Typically, when there is a suspicious death along these lines, the life insurance company will hold off on any payment. Certainly, if there was a big life insurance payout, we would have heard that in the prosecution's case.
Yeah.
So we're not sure one way or another.
Now, you say suspicion, but as we know, Brenden wasn't arrested until September of the following year. So not even that year. Juliana was arrested in October, but it wasn't until September that Brenden was arrested. But obviously we know that the police, that officers that have testified have said that they were kind of flagging things as they went, kind of had their suspicions. Specifically, Sally Fayez got up there and she talked about how they had an intel officer in the hotel who overheard a conversation between the 4-year-old daughter of Christine and Brenden Banfield and Juliana Perez-Magalis along the lines of, "Are you going to be my mommy now?" So do you think that's why maybe we haven't heard about it?
Well,
would that have been flagged?
In my experience, life insurance companies, or any insurance company, with all due respect to them, don't really open their checkbook right away.
Okay.
I think every viewer, every juror, everybody in this world would say, "Wow, it took me a little time to get some money from that insurance company." When there's any type of suspicion about
It's just
who
paused.
did something, it's usually going to be paused. It probably has been paused. I don't know if there was any claim that was put in. Maybe there was some pretrial litigation on this where the judge said, "You know what? I'm not going to let in any evidence of a claim being put in or whether there was life insurance." If there was an immediate payout, I think we would have heard about that.
Yeah.
So it could just be that everything was paused. I think that's probably the likely scenario.
All right, thank you for that context. Okay, one more question from a viewer that texted in. They said viewers this morning got glimpses of Christine in a pose and part of a conversation saying how anxious they are to have sex with each other. So the person is asking, do the jurors also see what's being shown on the screen?
The jurors see the way the evidence is being presented is it's presented to the witness first. The witness has to identify it.
Okay.
Then they have to move it into evidence. The judge has to agree, and then it gets shown to the jury. So yes, anything that has been moved into evidence, the judge has agreed, and it's in evidence, you'll see Judge Ascarati say, "Okay, it's in," or "Objection, okay, it's in." Once it's in, then is in that particular courtroom, then is then published to the jury, and they're able to see what the viewers have seen on the screen. Some things are put under seal that only the jurors are able to see. So the courtroom clerk is really doing yeoman's work, a magnificent job in keeping everything straight, because you don't want something flashed in front of the jury that hasn't been admitted yet. The courtroom clerk looks like he or she is doing a wonderful job keeping all the exhibits straight. That's not an easy job.
Which is why Judge Ascarati was very clear that she wants those exhibits numbered correctly and she wants things in early, on time, but in early if possible. She said she has her clerk working very hard on all of this. Somebody asked, or they more so just stated, that the prosecutor seems annoyed and trying to hurry the defense. When the jurors are looking at the prosecutor, and this is more my question, but is there a point where that kind of annoyance from the prosecution is going to have an impact on them? Is there a situation where the judge is going to be like, stop it?
Everybody's trying to pick up on the vibe of the jury.
Okay.
Right? So if you have 12 or 16 people to your left that seem impatient, then you want to make kind of an impatient objection. You want to say, oh, okay, no objection, this is taking too long, right? You want to play into what the jurors are feeling. There seems to be a little bit of a curtness or a quickness in some of the language coming from the prosecutor. We've seen that from the defense side as well. So I think everybody's just trying to catch the vibe of the jury and just react and object in that way. If you're feeling the jury's getting frustrated, you want to give an objection to kind of voice like, hey, I'm frustrated too, I'm with you. Whether that's successful or not, we'll see. What's going to be even more important, as we talked about, is what will these two prosecutors do when they cross-examine this expert? Because all of a sudden, it comes from very technical, and now you're on the spot where you have to confront a witness who really has a great deal of expertise.
Yeah, and I think we saw her when Detective Brenden Miller was brought up to the stand. She got up there and she was very quick. And she had her key points that she wanted to be like, but you can't prove this, but you can't show that. She was just very quick and to the point. Do you think there's a strategy there?
I think the strategy is, I don't really want to weigh in on this particular expert because they know more than I do about this subject matter. So I want to make my few points and I want to sit down. Again, I'm playing to the jury. Maybe they're frustrated and they say, wow, Mr. Carroll took 2 days to do something that Ms. Sands was able to do in 2 minutes.
Right.
That's an interesting strategy. I think that's probably what she will do. I am guessing the cross-examination here is much, much, much shorter than the direct testimony.
Right. All right, we're going back. I was actually planning to bring us back here anyway, but somebody said, Frank, all things considered, would you put Mr. Banfield on the stand?
I would not. I think that it's gone as well as he could have expected, but here's my disclaimer. Not being in there puts all of us at a huge disadvantage. If I'm in there and I can see how the jurors are looking at him, how they look at him when they leave for the day, you can tell somebody's body language. You can, if you're paying attention.
Right.
A lot of lawyers don't pay attention. If you just pay attention to what the jury is thinking and doing, they might be giving the vibe off of, yeah, he's guilty, and then you might think, I need to put him on the stand. At this point, I wouldn't, but if I'm in that courtroom and I see kind of the vibe of the jury, how they're looking at him, how they're looking at me, maybe I think, you know what, I'm going to put him on the stand. But his decision alone. So it doesn't really matter what I think or what Mr. Carroll thinks or the strong advice we might give him. If he wants to testify, he's going to testify.
Now, this is just purely speculation I'm asking you to weigh in on, but is it possible that the reason he's kind of slowly going through this witness is to slow down the process of Brenden potentially taking the stand and maybe have more time to convince him not to?
It could be. He could say at the end of this witness, and perhaps the prosecution doesn't do a bang-up job on this witness, he could say, Mr. Banfield, look at how well it's gone. You've gotten everything that you could ever imagine. You can't explain A, B, and C, or you're going to have a hard time, or you're going to be argumentative. Maybe he's giving him some time to sit and think and follow the advice of his attorney. People have testified over my objection before. Generally speaking, people have gone along with kind of the advice I've given. So we just don't know the personality of Mr. Banfield and what that relationship is like. But yes, there could be an element of delay in order to now go back to him and say, listen, you don't need to testify. We've talked about this. Maybe over the weekend they were vacillating back and forth on the issue, and now Mr. Carroll wants to say, see, I told you we did a great job. The prosecutor didn't hurt this witness on cross-examination. Don't testify.
Yeah, and I know you haven't spoken to John Carroll about, his plans or even this case really, but, if Brenden were to say, I want to take the stand, and he does take the stand, is there a situation where you can tell him no, or it's his right?
It's his right.
Okay.
It is absolutely his right. Now, the structure of the questioning can be a little bit different. I would expect, though, if you see how Mr. Carroll is, other than organization on the electronic exhibits, but you see how prepared he is with 300 and some exhibits.
Right.
A lot of trials, there's no defense exhibits at all because it's the government's burden of proof. But you see how prepared he is. If he does testify, Mr. Carroll's going to have a list of subjects to deal with,
Right.
exhibits to go through. It's going to be a very detailed examination. He's not just going to throw him up there and say, tell me what happened. Did you do it or did you not do it?
Right.
It's going to be detailed. He's prepared him one way or another, probably over the weekend. But if he doesn't testify, I think Mr. Carroll will then say, okay, Judge, I'm ready for a closing statement, and try to catch the prosecutor a little bit off guard.
You mentioned that you've had some of your clients object or testify against your objection. How did that work out for them?
One of my first jury trials ever was in Alexandria Circuit Court, where it was a robbery. There was an officer posing as an undercover officer, as a drug dealer, and my client got into it with who he thought was a drug dealer, but it was actually a police officer, and he wanted to testify over my objection. He testified, and it actually went really well for him.
Interesting.
He ended up getting convicted, but a much lesser sentence than his co-defendant, who was also involved. I think he got 5 or 6 years. The co-defendant ended up getting 20 or 25 years. So it has happened rarely that someone says, you know what, I'm going to take the stand and I know what I'm doing. These are not 100 to 0% calls. This might be a 55-45 call, and sometimes it works out okay. The vast majority of the time, though, having been through, hopefully, more jury trials than my client has been, it works out exactly the way you would expect. If we've prepared and he wants to take the stand, that usually goes very well. If I tell him or her shouldn't take the stand and they don't, that usually ends up better than if they overrule me.
All right, Frank, I know you've given us a lot of insight today. I think there are still some more questions, so I'll try to get to those, but I do believe court will be starting up shortly. So just a reminder, if you do have questions for Frank, even if he doesn't answer them today, he'll be back with us tomorrow or later this week. You can just text 202-895-5599, and we will keep a list of those questions and try to get them to Frank so he can answer them for you here on WUSA 9+. I do see these notes here where people are commenting about how we keep seeing Brenden taking notes aggressively, and somebody pointed out that they think he's taking all those notes because he wants to get up on that stand. In your opinion, is there a correlation between all the note taking and getting up on the stand? No.
Just for his personality, maybe. It has been a rare occasion where a client has written me a really good note that I then use in my examination. Usually, hopefully, I'm a step ahead in terms of knowing the rules and whatnot. I think that's just his personality. He's writing everything down. I think it's a reflection of his personality versus his intent to take the stand or not. But we'll see. He's definitely involved in his defense, which the jury can see one of two ways.
All right, I do see that we're getting more questions. We will try to get to those around 3:15 if Frank's able to stay with us. But it does look like court is starting back up. You see Brenden sitting down there. So let's take you back inside the courtroom as court continues today for day 9 of the Brenden Banfield murder trial.